to ask the Minister and the Chair for the current time. I just will note that it is apparent that urgent public business has kept the Prime Minister from doing his duties with this bill in the House. But I want to ask the Attorney-General to indulge his fetish with regard to jurisprudential matters, Mr Speaker. I'm going to give him a technicality on which he can get off. Mr Speaker, I want to refer him to page 5 of the bill, clause 5, subclause 3, and to ask him to look at the subclause which refers to incidentally obtained intelligence. Because what, Mr Speaker, this subclause says is that it means intelligence stroke A, that is obtained in the course of gathering intelligence about the capabilities, intentions or activities of foreign organisations or foreign persons, semicolon, but B, that is not the intelligence of the kind referred to in paragraph A. So how can we have intelligence that is obtained under a certain method about capabilities, intentions, activities of foreign organisations or foreign persons, but is not that? How, I'm sure the Attorney-General will have a simple legal explanation for it, but it seems to me if something is not something, then it can't be something. Well, and that's what this clause says. It says, well, known unknowns, says the member. It's the unknown knowns, I think, in this particular case. But it seems to me to be, I accept while I've been around this place for some time, I am not a lawyer, and there might be a good explanation for something, for intelligence, which is not around all the time in this bill, but I think in the GCSB connotation, intelligence, A, that is obtained in the course of gathering intelligence about the capabilities, intentions or activities of foreign organisations or foreign persons, but is not intelligence of the kind referred to in paragraph A. How can something be A but not A? I didn't do law, but I did philosophy and I did logic back in the day, and A but not A seems, and did a bit of maths, but A but not A is not a possibility. It is something which is absolutely illogical, and it seems to me that the Attorney... Well, I don't want to get metaphysical with the member. Mr Speaker, I think what we need to look at really carefully is whether in the rush to get this legislation through, there is a subclause here which has not properly been considered. Mr Speaker, Mr Chairman, I really, I know it's an old saying, but I am here from the opposition, and much as I like not helping, I think it is important that even in this appalling form, that we have a bill that is at least logically consistent and coherent. And I see from the way that officials are now looking carefully at it, and the pencils are out and they are writing, that we have a possibility of getting an amendment to this particular clause. And I want to remind members of the House that if we pass this clause, if we get this clause, we go past part 1 tonight, in order to recommit part 1, we will have to have a debate on the floor of the House in order to suspend standing orders to go back to the bit that we passed. So what I'm asking for, Mr Chairman, Mr Chairman, you put your arm out in a very primitive... Mr Chairman. Mr Chairman.
Chairman. Thank you, Mr Chairman. I want to pick up on referring to the